This is case number 254375OD and 254159SM. We are here for an arraignment on a new count in 4375 and a alleged bond violation in 4159. The allegation in 4159 is that he violated the no contact order by having contact with Douglas Willett. Douglas Willett was in the vehicle with him. Mr. May, you do have the right to have a contested hearing regarding that bond violation, at which the prosecution would have to prove to the court that there was in fact a bond violation, or you can always admit responsibility to that. Before we get to that, I want to cover the new charge. All right. Have you had the opportunity to discuss this case with someone from the public defender's office?
Yes.
I have a complaint that alleges that on or about October 12th, 2025, in the city of Cadillac of Wexford County, it is alleged that you committed the offense of operating while intoxicated. That is a misdemeanor punishable by not more than $500 and or 93 days in jail, additional suspension or revocation of a driver's license, vehicle immobilization for not more than 180 days, ignition interlock during any probationary period, and 360 hours of community service, rehabilitative programs, vehicle mobilization is mandatory with prior, and reimbursements for the cost of prosecution and governmental expenses. Do you understand those charges and the potential penalties?
Yes, sir.
Did you read and sign an advice of rights form at the jail? Talk about your rights to an attorney and your rights to a trial?
Yes, sir.
You do have the right to be represented by an attorney at all phases throughout this process, and if you could not afford one, one would be appointed to represent you, but you may be required to repay a portion of that expense. Do you understand that?
Yes, sir.
Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Can I request an appointment of an attorney?
And what is your current source of income?
I have two jobs, at Cadillac Casting Inc. and Burger King.
Court will make a referral to the public defender's office for the appointment of an attorney. Will enter a not guilty plea on your behalf and will set the matter for a pretrial. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. And we'll get to that in a moment. Ms. O'Mara, has your office discussed the potential bond violation with him?
Yes, Your Honor.
And do you know how he wishes to proceed with that?
Yes, he wishes to plead guilty. The bond violation is just to the no contact order. If it were to the OWI, it would be a no contest.
Well,
Judge, we never got a petition from the prosecutor's office on these violations.
I know, but he's at least arrested on it. So I know they've been tied up in circuit court. So I will now turn to Ms. Lawrence, and I understand the allegation is that he had contact with the co-defendant in this case, which was a violation of the bond. Do you anticipate any other bond violations coming out of the new charge?
Possibly.
All right. So then, what I will do today is I will accept a plea to the no contact violation, and I can allow the prosecutor to determine whether or not they are going to violate on any new charges that might rise. Does that make? Are you all right with that, Ms. O'Mara?
Yeah, I'm fine with that.
Okay. So you suppose, do you want some time to talk with the?
Well, I mean, can I just? We'll address the no contact order today.
All right. Mr. May, have you heard what the attorney has said is going to happen today?
Yes, yes, sir.
So let me break this down for you, just to make sure that you do understand. So it's my understanding that you're going to plead guilty to the alleged bond violation that you had violated the no contact order by having contact with Douglas Willett. Now, there is the possibility that the prosecution could choose to charge you with another bond violation arising out of the alleged operating while intoxicated. If they do that, that won't be dealt with today. That would be dealt with at a later date. You understand that?
Yes, sir.
So I want to make sure that you understand, even though you're dealing with a violation today, there's a possibility that in the near future, another violation could arise. Do you understand that?
Yes, sir.
Knowing all that, then do you still wish to plead guilty to the violation of the no contact order?
Yes, sir.
All right. Will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Mr. May, is it true that on October 12th? Yes, October 12th at a little after midnight, you must have had some law enforcement interaction?
Yes, sir.
And was Douglas Willett in the vehicle with you?
Yes, sir.
And did you know that on October 7th, I ordered that you not have any contact with Mr. Willett?
Yes, sir.
And so therefore you were in violation of the no contact order?
Yes, sir.
The council believes the defendants provided the factual basis to accept the plea to the bond violation?
Yes, sir.
Yes, Your Honor.
As does the court, I find the defendant has violated his term of bond by violating the no contact order. Ms. O'Mara, I'll leave it up to you whether you want to address bonds separately in this case or if you want to address it as a whole for both cases.
Let's address it separately.
Okay.
In regards to the bond violation, well, I agree that it's very recent that he was ordered not to make contact. I will say it was late at night. I don't believe it was a preconceived notion. He was like, I'm gonna go violate this bond order. From what I have been reported to, he was driving, he was in a car and saw the co-defendant and picked him up to give him a ride home. So I don't think there was some malicious, I'm ignoring this bond condition. I think it was a poor decision. And Mr. May has spent, a couple of days in jail there to think about that poor decision. And I think that he's come to the conclusion that he needs to take bond much more seriously than he has. And that's not to say that he hadn't taken it seriously. It's just, he's a young man. He made a poor decision. And he lives here in Cadillac. And I don't think that he's a flight risk. I understand the underlying charge. But he does work 2 jobs. And I do think that he will appear for court.
Lawrence, in regard to the bond violation.
Thank you, Your Honor. I'm going to ask for $1,000 bond in this case, as well as the other case, but I will address that after. Like I said, the defendant was arraigned less than a week ago, and he is already violating his no contact order with his co-defendant. I don't think the defendant is taking this seriously, which I think is pretty clear from the situation that occurred. Given that, the people are going to ask for $1,000 bond. Thank you.
Thank you. Well, Mr. May, the court takes its no contact orders very seriously, as I'm sure you've learned by now. I am not impressed at all, regardless of the reason. You knew there was you were not supposed to have any contact with Mr. Willett. The court doesn't do that because it feels like doing it. The court does it for certain reasons. And so now I'm left with, what do I do? Do I reinstate a bond? Do I reinstate your previous bond, or do I revoke bond because you're not following the court's orders? The court is going to amend the bond to a $500 cash surety bond with the same conditions as previously set. That brings us to the new charge, Ms. O'Meara.
Yes, Your Honor, for the new charge, I would just state that the alleged VAC taking was a .083, which, while above the legal limit, is not anywhere near what we see in this court on a day-to-day basis. I think that with increased bond conditions related to this case, being some sort of testing, some sort of alcohol testing, it would become clear relatively quickly if he was going to take bond seriously. So I would ask for similarly a low cash bond in this case. Also, I apologize. His sister is here today to as a community support and is supporting Mr. Thank you.
Thank you, Ms. Lawrence. I know you said some things, but I'll give you the opportunity again.
Thank you, Your Honor. While I do understand the defendant's PBT was a .083, which Ms. O'Meara is correct. We do see a lot higher than that, but that still is over the legal limit to drive. And on top of that, the defendant is not of the legal drinking age, so he should not be drinking at all, let alone when he is out on bond. With our court, he picks up a new charge. I'm going to ask for a $1,000 bond in this file as well as random alcohol testing. Thank you.
Ms. O'Meara said we'll know within a short period of time whether he'll take the bond conditions seriously. We already have that answer because in the other case, he didn't take the bond conditions seriously. And it's not lost on the court that he's 19 years old, not anywhere near the age of drinking yet. What brought him to the attention of law enforcement, Ms. Lawrence?
Looks like fluctuating speed, observed speeding, crossing the double line. Eventually that led to a traffic stop.
Your Honor, if I may.
If it has anything to do with the facts of the case, I don't think you should. You have the right to remain silent. If it's anything you want me to consider regarding bond outside of the facts of the case, you may.
Never mind then, it's fine.
I'm going to order that the defendant appear as ordered, keep his contact information current, not leave the state without permission, and commit no new crimes. Additionally, he's going to be subject to a no alcohol provision with random testing and a no drug provision along with random testing, including recreational marijuana. Bond will be set at $250 cash surety. Next arraignment. Person at the jail, what is your name?
Jason Herman.
This is case number 2543770M, the people of the city of Cadillac versus Jason Stephen Herman. Sir, did you have the opportunity to meet with somebody from the defender's office today?
Yes, I did, Your Honor.
And the contact information that you gave, which is essentially just an address to community corrections, is that address accurate?
Yes, the 217 East Pine, yes.
I have a complaint that alleges that on or about October 11th, 2025, in the city of Cadillac for Wexford County, it is alleged you committed the offense of disorderly drunk. That is, Ms. Lawrence, your punishment is not listed in your complaint.
I apologize, Your Honor. We can get.
Is that a 95? That is a 90-day misdemeanor with a fine of up to $500. Do you understand those charges and the potential penalties?
Yes, Your Honor.
Do you remember reading and signing an advice of rights form at the jail to talk about your rights to an attorney and your rights to a trial?
Yes, I did.
You do have the right to be represented by an attorney at all phases throughout this process, and if you could not afford one, one would be appointed to represent you at public expense. but you may be required to repay a portion of that expense. Do you understand that?
Yes, I do, Your Honor.
Today, are you requesting the appointment of an attorney? Do you wish to represent yourself or hire an attorney?
I was wondering if I could get one appointed.
What is your current source of income?
Right now, the place I'm living, I'm doing construction in it and I'm putting applications out.
Court will make a referral to the public defender's office for the appointment of an attorney, enter a not guilty plea on your behalf. We'll set the matter for a pretrial. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. The counsel, Mr. Herman, has a lengthy record, including similar charges for this. The praxis scores him at a risk level 5, so medium risk. Any comment regarding bond, Ms. O'Meara?
Yes, Your Honor, I realize that the defendant has similar allegations or convictions in the past. I would state that he has found stable housing here in Cadillac at 217 East Pine Street, which is nearby, will allow him to appear in court. I think that well, I don't know the specific allegations in this case. I don't believe anything particularly absurd is alleged. I would state that sorry, the housing that he's found is around people who don't drink or who are responsible. There's a presumption of no jail time in cases like this, and while I would expect that the criminal history may qualify that somewhat, I would state that I would ask for a personal recognizance bond. Thank you.
Thank you, Ms. Lawrence.
Thank you, Your Honor. This occurred between 3 o'clock in the morning and 6 o'clock in the morning. The defendant was banging on apartment doors in Harborview apartment and yelling, which clearly awoke several people. There was a PBT done as well, which came back at a 0.268, which is extremely high. Given that people are going to ask for random alcohol testing, I am tempted to ask for a no contact order with the Harborview apartments, but frankly, it didn't seem like the defendant knew how he had gotten there. He claimed he was looking for his friend, but clearly he was pretty heavily intoxicated, so I will leave that up to the discretion of the court. I think given this, as well as the defendant's criminal history, a monetary bond could be appropriate, but I will also leave that up to the discretion of the court.
Thank you. Mr. Herman, I am going to release you on your personal recognizance, which is your promise to come back to court. You are to appear as ordered, to keep your contact information current, not leave the state without permission, and to commit no new crimes. Given your level of intoxication and the fact that it was an intoxication that was creating a disturbance at a private apartment complex, I am going to order that you not consume any alcohol and you'll be subject to random testing. I'm also going to order that you not have any contact with Harborview Apartments. And that you not act in any threatening, intimidating, or harassing behavior. All right?
Yes, Your Honor.
All right. Next arraignment. Person in the jail, what is your name?
Scott Mosek.
This is case number 254354 FY, the people of the state of Michigan versus Scott James Bozak. Mr. Bozak, you met with somebody from Community Corrections today and gave them some contact information. Is that information accurate?
Yes,
Did you have the opportunity to meet with somebody from the defender's office today?
yes,
I have a complaint that alleges that on or about October 10th, 2025 in Herring Township of Wexford County, it is alleged in count number 1 that you committed the offense of deliver or manufacture methamphetamine. In particular, did deliver or possess with intent to deliver methamphetamine. That is a felony. Lawrence, your penalty is not filled in there either. That is a 20-year felony and or a fine of $25,000. The prosecution has elected to charge you as a second subsequent offender, which means you have at least one prior drug conviction in your past. That makes that 20-year felony a 40-year felony, and the $25,000 fine a $50,000 fine. In count number 2, it is alleged that you committed the offense of weapons felony firearm. That is a felony punishable by up to 2 years in prison with a mandatory 2-year consecutive sentence imposed on the underlying felony and mandatory forfeiture of the weapon. Additionally, in count number 3, you're charged with controlled substances maintaining a drug house. That is a felony punishable by up to, that's a high court misdemeanor punishable by up to 2 years in prison and or a fine of $25,000. The prosecution has also elected to charge you as a habitual offender's second offense notice, which means that you have at least one prior either attempted or completed felony in your past. That would make that count number 3 of maintaining a drug house a 3-year felony. And if they move forward on that with the PWID or the 10-year felony, it would make that a 15-year felony. Do you understand those charges and the potential penalties?
I believe so.
Did you have any questions about those?
How is there multiple of the 3 drug house felonies?
There's only one drug house charge. It was count number 3.
Okay,
Does that make sense?
yeah,
All right.
I believe.
On felony complaints, you have well, you say you believe. Do you have any other questions for me?
I'm just not 100% sure on all of them. They came kind of quick.
Do you understand that with the information that the prosecution has, they have elected to charge you with either delivery or possession with intent to deliver methamphetamine? Do you understand that?
Okay,
They've also elected to charge you as a felony firearm, meaning that during the commission of a felony, you were in possession of a firearm. Do you understand that?
yes,
And they've also elected to charge you with maintaining a drug house. Do you understand that?
okay, I understand better. Thank you.
Oh, okay. Did you understand the potential penalties that went along with those charges?
Yes,
All right. On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning that you consent to, and you have the right to stop answering questions at any time. You also have the right to be represented by an attorney at all phases throughout this process, and if you could not afford one, one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Do you understand that?
yes.
Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
So far as request the appointment of attorney.
What is your current source of income?
I do construction work for You're Good. I do mechanic work on the side, and I also help with drywall to another company.
All right, court will make a referral to the public defender's office for the appointment of an attorney, will enter a not guilty plea on your behalf, and will set the matter for a prelim. The preliminary examination is a hearing that's held here in the district court within 21 days. At that hearing, the prosecution is required to prove 2 things. 1, probable cause that these crimes had occurred, And 2, probable cause that you were the person who had committed the offense. If the prosecution is not able to do that, the case would be dismissed. But if they are able to do that, you'd be ordered bound over to stand trial in circuit court. Prior to the preliminary examination, there'll be a probable cause conference. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. Do you understand that?
Yes,
You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel in 10, I show a possession of marijuana in a drug house, 2 separate convictions. In 18, an operating while intoxicated second, failed to stop at the scene of a personal injury accident, driving while license suspended, operating without security, and use of a controlled substance. In 23, allowing another person to operate in violation of the motor vehicle code, a driving while license suspended, another driving while license suspended second. In 24, driving while license suspended, and another driving while license suspended second, and lawful plate. And in 14, there was a visibly impaired. Any comment regarding bond in the praxis scores at a risk level 2? Ms. Amara?
Yes, sir. Mr. Bozak lives in Cadillac here. His wife also lives in Cadillac. The previous conviction of a similar sort had to deal with marijuana, so I don't believe that they are exactly parallel charges, especially considering the legal status of marijuana now. He's an active community member. He helps out around his community. He's a construction worker, and he has been for the past 15 years. He's a responsible member of the community. Well, a responsible member of the community in that aspect. The driving charges aren't of a similar nature. That would state that. I'd ask for a low cash bond or a personal recognizance bond because I do believe he should appear as ordered. Thank you, Your Honor.
Lawrence?
Your Honor, unfortunately, I do not have a police report yet, so my facts are also limited. I do know that 16 grams of methamphetamine were found, possession of the defendant, as well as multiple small clear plastic Ziploc baggies. These charges are extremely concerning, especially with the idea that the defendant intended to distribute this methamphetamine. I do think that is a huge concern for public safety. Given that, I am going to ask for a $200,000 bond as well as random drug testing.
What can you tell me about the firearm?
All I know is it was a Taurus Spectrum .380 handgun, and it was found in the defendant's camper.
without fire.
All right, based on the nature of the allegations, in that this was either a delivery or a possessed with intent to deliver, the amount of alleged methamphetamine discovered of 16 grams, and the fact that there is a firearm, at least allegedly, there is a felony firearm in this case, I do find that the defendant poses a threat to the community. Bond will be set at $100,000 as surety, with the following conditions: that he appear as ordered, keep contact information current, not leave the state without permission to commit known other crimes, be subject to no drug provision, including recreational marijuana and random testings, that he not purchase or possess any firearms or weapons, that he not act in any threatening, intimidating, or harassing behavior, that he be placed on GPS tether, house arrest, or the conditions set by community corrections. Next arraignment. What is your name?
Miranda Bozak.
This is case number 254353 FY, People of the State of Michigan versus Miranda Renee Bozak. Ms. Bozak, you met with somebody from Community Corrections today and gave them contact information. Is that contact information correct?
Yes.
Did you have the opportunity to meet with somebody from the Defender's Office today?
Yes.
I have a complaint that alleges that on or about October 10th, 2025, in Herring Township, Wexford County, it is alleged that you committed the offense of possession of methamphetamine That is a misdemeanor punishable by up to 10 years in prison and or a fine of $15,000. Do you understand those charges and the potential penalties?
Yes, I do.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning that you consent to, and the right to stop answering questions at any time. You also have the right to be represented by an attorney at all phases throughout this process, and if you could not afford one, one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Do you understand that?
Yes, I do.
Today, do you request the appointment of an attorney, to hire an attorney, or represent yourself?
The court appointed,
What is your current source of income?
unemployed,
The court will make a referral to the public defender's office for the appointment of an attorney, will enter a not guilty plea on your behalf, and will set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecution is required to prove two things: one, probable cause that this crime had occurred, and two, probable cause that you were the person who had committed the offense. If the prosecution is not able to do that, the case would be dismissed. But if they are able to do that, you'd be bound over to stand trial in circuit court. Prior to the preliminary examination, there'll be a probable cause conference, which will be an opportunity for your attorney and the prosecutor to get together to see if there's a way to resolve the case short of going to trial. Do you understand that?
yes, I do.
You also have the right to have a bond set. Your bond is based upon the probability of you appearing in future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Historically, counsel, I show in 24, there was allowing another to operate in violation of the motor vehicle code. The praxis does score her at a risk level 4, so medium risk. Any comment regarding bond, Ms. O'Mara?
Yes, Your Honor. This is just your second charge of any nature, and certainly your first charge that is serious. I would state that she lives in Cadillac. While she isn't employed, she's a homemaker, so she stays at home, so she's not employed. I would ask for a personal recognizance bond in this case. Testing as the court sees fit.
Thank you. Ms. Lawrence?
Thank you, Your Honor. I will admit my information is even more limited in this defendant's case. I do know that the defendant admitted to smoking methamphetamine and also admitted that it was provided to her by the previous defendant, Mr. Bozak. My concern here is the involvement with the amount of methamphetamine that was found and other things found in the camper. I do not know their relation to each other or the living situation, unfortunately, because I do not have a police report. Given that, I do think it is a little concerning to public safety. I'm going to ask for a $10,000 cash bond as well as random drug testing in the meantime. Thank you.
I realize you're probably working from probable cause affidavits, but do we know, are the two from the same location? I mean, I note they're both in Herring Township. They both have the same last name.
I believe it is the same location, Your Honor, the same address.
Right. Ms. Bozak, as a condition of your bond, I'm going to order the following: that you appear as ordered to keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm also going to order that you not consume or any illegal controlled substances. I'm going to include recreational marijuana, and you'll be subject to random testing. I'm also going to order, yeah, I believe these two cases are very closely linked. So I am also going to order that there's a GPS tether along with house arrest, the conditions set by community corrections. In regards to the amount, I'm going to set for right now a $25,000 cash surety until I know more about the case. Thank you, Ms. Bozak. Corrections, are we able to arraign Mr. Lexikoff?
Could you give me a second, Your Honor, and I'll see how things are going?
All right.